Hello. Please welcome to Child Abuse Awareness with Darlene J. Clark. Please like, subscribe, and share. In Matthew 18, verse 10, take heed that you despise not one of these little ones, for I say unto you, that in heaven their angels do always behold the face of my Father which is in heaven. Matthew 18, verse 6, but whoso shall offend one of these little ones which believe in me, it were better for him that a millstone were hanged about his neck, that he were drowned in the depth of the sea. The Copyright Disclaimer under Section 107 of the Copyright Act of 1976. Allowance is made fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is the use permitted by copyright statute that might otherwise be infringing. Non-profit, educational, or personal use tips the balance in favor of fair use. Thank you today. We're doing about Florida's sexual abuse laws and bills. I thought this was important to go over. So we'll go back over here to start this presentation where you can see, share the screen. Okay. So now we'll go over. This is where hg.org, Sexual Assault Florida. It said Florida Sexual Assault and Abuse Law. What is Florida Sexual Assault and Abuse Law? Penalties for conviction of sexual assault or sexual abuse in Florida are severe. Individuals for being charged with a sex crime in Florida should be aware of the nature of the charges against them, possible consequences they face upon conviction, potential defenses that they may be able to raise, and other important information related to these charges. Good to see you again as well, Jackie. Thanks for coming to support. Appreciate you so much. The new law about the well, it's going to be in here. It's going to be different laws pertaining to Florida. Sexual assault charges in Florida. Sexual assault includes any unwanted sexual contact that is made against another. Florida statute includes oral, anal, or vaginal penetration by another or foreign object in its definition. Most commonly, these charges arise when one person tries to force another to take part in an unwanted sexual act against his or her will. Sexual assault victims often face a great deal of fear, shame, and emotional trauma. Victims of sexual abuse may have difficulty forming and maintaining personal relationships in the future. Victims often state how the incident affects the rest of their life. Prosecutors often believe victims of these crimes, due to the sensitive nature of them, and may be more aggressive in their pursuit than in any other crimes. These cases often rely heavily on the victim's testimony. These charges are some of the most difficult to defend, increasing the importance of acquiring an experienced criminal defense lawyer for assistance. Sexual abuse is defined under Florida law as the forcing of unwanted sexual activity on another individual through coercion or threats. Sexual abuse may be charged when an adult takes pictures of a child in the nude, touches a child in an inappropriate manner, or acts in a sexual manner towards a child. These crimes are often committed by someone familiar with a child, such as a relative or neighbor. Thank you. Penalties for sexual assault or sexual abuse. Because of the significant consequences that the victim or sexual assault or abuse can face and the public's pressure associated with sex crime convictions, the penalties for this crime have increased over time. Sexual assault is considered a felony even when the act was only attempted and not committed. The most serious consequence a person faces is imprisonment for a number of years or even life if convicted. Sexual assault can result in a second-degree felony conviction, which is punishable by up to 15 years in prison and fines up to 10,000. Can also be charged as a capital or life felony with the possibility of life imprisonment and fines up to 15,000. Sexual battery of a child in Florida is penalized heavily. If the victim is under age 12 and the defendant is also a minor, the defendant may be charged with a life felony and a minimum of at least 25 years in prison. If the offender is 18 or older, the defendant may be given a death sentence for the defendant. See right here? If the child is over 12, a prison sentence of up to 15 years may be imposed. Additionally, a person convicted of an offense of this nature often must register as a sex offender. Convicted individuals may have to pay significant fines. They may be required to fulfill a term of probation or parole and wear a tracking device. Yep. As I said, glad the laws are getting tightened up. There are new laws about safeguarding children online. Oh, yeah. I'm glad they're finally doing something, at least here. Let's see. The actual sentence that is imposed depends on a number of factors, including the age of the victim, the age of the offender, and the circumstances surrounding the offense. For example, when the defendant is 18 or older and the victim is younger than 12, sexual assault charges may result in a capital felony, which carries a minimum of 25 years in state prison before becoming eligible for parole. When a weapon is used or threatened to be used, a life felony may be charged, carrying it with a potential life term in prison and hefty fines. If the offender is under 18 and the victim is under 12, life imprisonment may be imposed. If drugs were used to incapacitate the victim or the victim was physically or mentally incapacitated and could not resist, the defendant may face up to 30 years in prison in addition to fines. If physical force was not used, a second-degree felony with up to 5 years in prison may be charged, in addition to considering the age of the victim and offender. The court can consider the severity of the abuse and the number of independent instances of abuse. A mandatory 25-year prison sentence can result if the defendant is considered a dangerous sexual offender. The status can apply when the defendant causes serious injury, the defendant used or threatened to use a deadly weapon, the defendant committed the offense of more than one person, or the defendant had a prior sex crime conviction. Other circumstances exist in which the defendant may face additional penalties and enhancements in sentencing due to his or her prior criminal history. If I think a lot of countries are taking new laws on board, we need to be more hyper vigilant about even not letting our children marry and young children marry adults. Due to their sex offender registration status, convicted offenders may be restricted as to where they may live. They may be prohibited from living in subsidized housing. Their employment opportunities may be limited. They may lose a current job or be unable to find employment because of their criminal record. They may be unable to secure student loans in order to enroll in college and increase their earning capacity. They may be unable to acquire a professional license or work around children. There are websites that neighbors can use to find sex offenders in the area, which may lead to harassment by others and a negative social stigma in their community. Like I know there was that police officer, and he was still allowed to be a police officer, even though he wasn't allowed state trooper no more. But then they still hired him as a regular police officer in the city, and that was wrong by all counts. Then where we lived, he actually was living above in the apartments near same apartments as me, but a different building. And he was one of my sexual predators as a kid. It was his daddy who trafficked me as a little girl. I mean, did that child pornography. He was the one that told me that I enjoyed doing you as a kid when I think about it. This police officer was a state trooper and still was out there. He shouldn't have been able to be a police officer either. Additionally, individuals who are convicted of a sexual offense may be deprived of their custody or visitation rights to their own children, as should be. Individuals who are convicted of this crime, or even when they are not, may still be subject to civil consequences. Victims can seek damages for medical expenses, psychological treatment, and pain suffered by pursuing an independent civil lawsuit. Sex offender registration in Florida. After conviction of most sex crimes in Florida, the defendant is required to register as a sex offender. This database is controlled by the government. Information is updated about the offender's location and place of employment. Neighbors and employers can request information about sex offenders and their location. Sex offender registration prohibits sex offenders from living by schools or other places where children are commonly present. The apartments where we lived, it overlooked a playground next to a school, and he was a sex predator for kids. Thank you so much. And they didn't make him register. They probably just, I don't know, the other neighbors had told me that, yeah, he got busted with the child pornography, some of it. Hopefully they ended up getting all the child pornography stuff, but he was still able to serve as a police officer, and that's not right. It was just still able to live in an apartment that overlooked a playground where kids played in. It was still able to do all that. Live right beside a school where the small kids went to school. They're still able to do all that. There may be a number of plausible legal defenses that a defendant may raise when facing charges of sexual assault or sexual abuse in Florida. The defense strategy that a defendant's criminal defense lawyer lodges will depend on the circumstances surrounding the case and the relationship between the alleged victim and the defendant. Some possible defenses include A. Innocence. A person may be accused of sexual assault or abuse when he or she did not actually commit the crime. The alleged victim may be confused about what happened or may simply be lying because he or she is ashamed for some reason or trying to cover up his or her own acts. The victim may not have been sexually assaulted or abused. Yes, it is. I do not trust Alabama to really protect me. They never did. Mistaken identity. In other cases, the victim may have been sexually assaulted or abused, but may be confused about the identity of the person who committed the crime. The victim may not have seen the offender. A neighbor or other eyewitness may have identified the wrong person. The victim or the eyewitness may have recognized the defendant from some other encounter. Photo arrays and lineups are not always dependable. Consent. If the victim was old enough and mentally and physically able to consent and did consent, the sexual assault did not occur. Impossibility. If the victim alleged that the act was committed in such a manner that would have been physically impossible for the defendant to complete, this defense may arise. Alternately, Alternatively, if the defendant was in a place that was too far away from him or her to be in the place alleged to be the location of the assault, the defense may be asserted. Diminished capacity. Another possible defense is that the defendant did not have the requisite mens rea of mental state to commit the crime. He or she may have had diminished capacity or mental instability at the time of the offense. And I know some that's mentally handicapped and that just got like a fifth grade level, 5-year-old level. And no, they don't have the capacity like when they're 5 year old. I know somebody like that that's living in a home because he's too much to take care of because for his brother, even though he's an older man now, just because, well, when he was 5 years old, he ended up having a severe fever and it messed with his brain that it never grew. He even has trouble even giving himself baths or anything. So I can understand that defense in such cases like that. In some cases, law enforcement may overstep their legal abilities and may violate the defendant's right. Exactly. When this happens, evidence that could have been used against the defendant may be suppressed. For example, law enforcement may have searched the defendant's residence without a warrant, or they may not have read the defendant his or her rights when required to do so. False accusations. One of the most common defenses to allegations of sexual misconduct is that the defendant is being subjected to false accusations. False accusations regarding sexual offenses are far too common. These allegations often arise during a divorce or child custody case. Florida law permits victims of domestic violence to secure an order of protection. This important order is intended to protect victims of domestic violence from further harm. However, these orders can sometimes be misused because of the benefits that they provide, such as an established and temporary amount of child support or spousal support, ordering a spouse out of the marital home, ordering property rights to the alleged victim, and awarding custody to the petitioner. In other cases, a spouse or romantic partner may allege that the defendant sexually assaulted him or her with the hope of receiving a larger share of the marital estate. He or she may hope to use the charges as leverage to resolve the civil case, such as divorce or child custody. A parent may even coerce his or her child to say that the other parent or the other parent's romantic partner sexually abused him or her in order to gain sole custody. In other situations, a bad breakup or bad blood between the parties may provide incentive to act in a bitter manner toward the other party. False accusations can be difficult to establish, and prosecutors may not believe the defendant's assertions of innocence. Then there's a legal assistance here. Individuals who are suspected of committing a sex crime, such as sexual assault or sexual abuse, should be aware of their rights. Usually, it is recommended by criminal defense lawyers not to speak to law enforcement and to invoke the right not to speak. If necessary, a criminal defense lawyer can speak on the defendant's behalf and avoid making any incriminating statements. If arrested, the defendant will want to indicate that he or she wants a lawyer and will not say anything else until his or her lawyer arrives. Due to the significant consequences of a conviction, a defendant must take these charges seriously. Simply hoping that the charges will go away is not a thoughtful strategy. The sooner a criminal defense lawyer is contacted, the faster he or she can take steps to protect the defendant. There was a case where I had a boyfriend, and the boyfriend's son got really angry at me. So he said that he was telling somebody that I essayed him, and I ended up taking him to his grandparents' house with the daughter also, and he and her both confessed that they lied, that he lied, that I never did nothing to him, and he was just mad at me for not doing something that he wanted. And they said, "You never lie about nothing like that. You never lie trying to get somebody in trouble about sexually abusing when they didn't do it." So then he was very angry at me for doing that. But I did that because I didn't want to end up going to jail for something I didn't do, all because of the fact that he was angry. Additionally, even the belief that a person is suspected of a crime of this nature can attach negative social stigma to him or her, so it is pivotal to act immediately. Law enforcement is not incentivized to explore the possible biases that may be impacting the charges against the defendant. So it is important to retain competent legal counsel who explore the nature of the charges against the defendant and the circumstances surrounding them. A criminal defense lawyer may ask the defendant to think about any reasons why the alleged victim or his or her family may be making the allegations so that he or she can build a legal defense strategy around this information. He or she can help negotiate a plea bargain with the prosecution or lodge a defense in a criminal thing. But right now, we want to focus on legislation and the different laws surrounding it. And when the Florida sex offender laws, what you need to know, who is considered a sex offender in Florida. As a general rule, an individual who is convicted, not just charged of a sex crime act, where federal or state laws would require his or her name to be placed on the sex offender registry, is considered a sex offender. The laws in Florida cover a broad range of crimes. If you are charged and convicted, you would have to register as a sex offender. Additionally, if you have been convicted of certain sex crimes in another state and then moved to Florida, the state will recognize that conviction under the law, and you will be considered a sex offender. Yes, I did. I knew what I had to do about getting my story out, and I wasn't going to let somebody end up accusing me of something I didn't do when I knew I had this purpose, and it really hurt me bad for him to accuse of such a thing. Here are some of the crimes upon conviction which would define you as a sex offender: luring or enticing a child, sexual misconduct, false imprisonment of a minor, kidnapping of a minor, human trafficking, child pornography, video voyeurism of a minor, lewd or lascivious offense with a minor, unlawful sexual activity with certain minors. If you have been charged with any of the crimes listed above, contact the Denson firm for free. Whatever. Sexual offender versus sexual predator. What's the difference? Florida sex offender laws define the two based on the level and number of crimes. Sexual predators are considered even more serious and have stricter registration requirements. For someone to be classified as a sexual predator, he or she has been convicted of at least one first degree felony sexual misconduct charge or two second degree sexual misconduct charges. Excuse me, I still call my parents sexual predators since they went around trafficking me, but they never did pay for the crime. So even though they never paid for the crime or anything, they were still sexual predators. He would rape me. He would do different things. He was a sexual predator. He raped my sister, everything like that. He's a sexual predator. He was in the military. They put him in the brig because in another country because he was raping girls from that other country. But they never did kick him out of the military. They still let him be in the military. He never got a dishonorable discharge or anything. But they never gave him the sex offender thing. Because back then it was unheard of, back in the 70s, 60s, and 70s. The sexual offender registry is in place to keep track of the location of the individuals who have history of molesting or abusing children. They must register with local authorities and keep the police aware of their presence in countries and counties across the state. If the individual is traveling to another state, not other residents, they are required to let local law enforcement know. Each year, updated information must be provided to local authorities including occupation, place of employment, vehicle information, residential information, all phone numbers, all email addresses. Additionally, authorities must be notified if the individual plans to travel or move out of the state. Complete registration requirements are listed in Florida Statute 943.0435. Who has to register? Sex offender laws in Florida require that anyone who has been named a sexual offender by the criminal justice system due to a conviction of a certain sex crime. How long do I have to register? Once an individual pleads to a particular sex offense that mandates registration, that person has to keep registered for the rest of their life. What happens if I fail to register? If someone fails to register after being mandated to register by law, it is considered a third-degree felony. The punishment will be determined by how many times they have failed to register. First offense, 6 months with electronic monitoring mandatory minimum. Second offense, 1 year with electronic monitoring mandatory minimum. Third or subsequent offense, 2 years with electronic monitoring mandatory. Can I be removed from the Florida Sex Offender Registry? Under Florida sex offender laws, it is difficult to be removed from the list, but not impossible. A few potential options and a limited number of offenses qualify for removal from the Florida Sex Offender Registry. Potential options include a full pardon from the state of Florida. The individual moved to Florida from another state with a sex offender designation. That designation has been removed. Post-conviction relief, where a request is made to the state that conviction or sentence be corrected or vacated. Romeo and Juliet law, where an individual meets the requirements that apply to certain sex offenses that involve people who were no more than 4 years older when he or she engaged in a sexual relationship that was consensual with another individual 13 to 17 years old. After 25 years on the Florida Sex Offender Registry, an individual may request to be removed while still having strict restrictions. Offenses that can qualify: a lewd or lascivious exhibition using a computer online, sexual performances by a child, lewd or lascivious offenses committed upon or in the presence of persons under 16 years of age. How I'm gonna not speak about how criminal defense because we're going differently here. Now here's Governor Ron DeSantis announces law and order legislation. And this was January the 26th, 2023 in Miami. Governor Ron DeSantis announced his legislative proposal to maintain and further improve Florida's 50-year record low crime rate. This proposal pushes back against abolishment of cash bail, increases penalties for drug-related crimes, steps up human smuggling interdictions, strengthens the punishment for child rapists, prevents the early release of sex criminals, and makes it more feasible to administer ultimate justice to those facing the death penalty. More details on the governor's proposal can be found here. Other states endanger their citizens by making it easier to put criminals back on the street. Here in Florida, we will to continue to support and enact policies to protect our communities and keep Floridians safe, said Governor Ron DeSantis. Florida will remain the law and order state. While some states are adopting soft on crime policy that's increased lawlessness and decreased public safety in Florida, we strive to strengthen our laws, keep violent criminals behind bars, and take proactive steps to keep our communities safe, said Attorney General Ashley Moody. I want to thank Governor DeSantis for always standing up for the rule of law and taking action to fortify public safety measures to ensure we continue to be the best state in the nation to pursue the American dream. Governor Ron DeSantis knows the importance of keeping families safe, and because of that, his commitment to law enforcement is unprecedented. The Florida Department of Law Enforcement Commissioner Mark Glass. We're thankful to live in Florida. So many of our law enforcement colleagues across the country just don't have the support of leaders like Governor DeSantis. See, I lived in Florida before, but they didn't protect me. But now it's changed. This legislation will bolster Florida's blueprint for fighting crime by reforming Florida's death penalty statute to ensure that those convicted of the most heinous crimes are punished accordingly. Current law requires a unanimous jury recommendation to impose a death sentence. This proposal reduces the number of jurors required for a recommendation of death from unanimity to a supermajority jury recommendation. So if one goes, that's against the death penalty, but if the majority says death penalty, it can still go through. Addressing the ongoing fentanyl crisis that is plaguing our country by imposing additional penalties on fentanyl and other drug-related crimes when the drug's appearance resembles a piece of candy, including making it a first-degree felony to possess, sell, or manufacture fentanyl and other controlled substances that resemble candy, and adding a mandatory life sentence and 1 million penalty for trafficking such substances that target children. Additionally, Governor DeSantis is allocating 20 million in local support funding for law enforcement agencies to increase efforts to interdict and apprehend the illicit sale and trafficking of fentanyl. This builds upon last year's increase in fentanyl trafficking mandatory minimums and will protect vulnerable children who might be deceived by what was dubbed rainbow fentanyl. Strengthening Florida's bail laws by limiting who is eligible for release prior to first appearance, making sure that the judge is the ultimate decision maker when it comes to detention, and requiring a detention hearing to be held prior to trial for dangerous crimes. Good. Petitioning Florida Supreme Court to establish a uniform bond schedule that all state courts must follow. Required convicted child rapists to serve at least life in prison. You see that? Requiring convicted child rapists to serve at least life in prison. Exploring options to make them eligible for the death penalty. Toughening penalties for sex criminals by expanding the list of crimes ineligible for gain time by adding an inchoate offenses, attempted crimes of sexual misconduct such as attempted sexual battery. Requiring law enforcement to report missing persons to the National Missing and Unidentified Person System. Currently, they're only required to report it to the Florida Crime Information Center and the National Crime Information Center. See the difference there? They're required to report missing persons to the National Missing and Unidentified Person System. How about that? That's a big plus. because they're regularly required just to report it to the Florida Crime Information Center and the National Crime Information Center. But they can't say that it's a crime. You cannot put it in a missing person some of the time then, huh? Dedicating $5 million in the upcoming budget recommendations to continue the successful interdictions by the strike force announced last year. To date, these interdictions have resulted in more than 200 felony charges, nearly 40 human smuggling charges, 66 drug charges, and more than $625,000 worth of illicit drugs seized. This law and order legislation will be in addition to Governor DeSantis' previous public safety initiatives, including Hallmark anti-rioting legislation, strongest law enforcement recruitment and support initiative in the nation, and a crackdown on opioid dealers and drug traffickers. Because of these policies, Floridians are enjoying a 50-year record low crime rate, and year-over-year crime in Florida is down nearly 10%, with murder down 17%. And need to go ahead and close that one out. And I noticed also that this also toughens it, which, while other states endanger their citizens, that's basically the same thing. We just got the reading. And this is here where the law and order, Governor DeSantis is proposing an anti-crime legislation to further cement Florida as a law and order state. There's where it goes from fentanyl, keeping dangerous criminals out of communities, combating human smuggling, and tougher penalties. Right here. There was something else that I had seen too that I'm not seeing it right here at the moment. So I am going to look it up right quick. Um, and okay, it's got to come up. This was August 23, 2022. License plates. See this? Registered Florida sex offenders can be forced to use a distinctive fluorescent green license plate with the passage of a bill making its way through the state legislature. So if somebody just going down the road, they're going to know that that's a sex offender. An amendment added by Democratic Senator Lauren Book, Senate Bill 1252, was filed on Tuesday. It would give authorities the power to assign a distinctive fluorescent green license plate to vehicles owned, leased, or operated by persons who are designated as sexual predators in Florida. The bill also seeks to mandate all registered sex offenders to have the word sexual predator printed on the front of their driver's licenses in the color of red. In order to become law, the bill will first need to pass through the Florida House and Senate before being signed by the governor. If passed, it would take effect on January the 1st, 2024. So these are all a lot better thing that they will end up having to cross their licenses, and you got to show your license a lot of times. You see somebody could get if you see somebody's license, and like if you're on a date with somebody, for instance, right? Somebody comes to pick you up in a car, and then you don't really know the person, and they got one of those sex offender license plates. Do not get in a car with them. No, 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 for sure. Wow. So please like and share, follow and share this because I think a lot of people need to know. And I hope that we can get more laws like this and bills passed like this across the United States, across the world, because we do not deserve to suffer with the pain and the heartache. These people responsible need to pay for the crimes that they have done to other people, to kids. So thank you so much for coming, and please share this with other people. I appreciate it, and I appreciate it. God bless you.